Ashlesha, you're not visible. Please turn on your camera.
Okay.
Ritika, can you please check the YouTube feeds?
Yeah. Then check the YouTube feeds. Keep a check on it throughout and take screenshots also. Thank you.
Are we marking attendance right now?
Yeah. Then check the camera. Good evening, sir. So everyone, we have with us Professor Dr. R. Venkatrao. Sir, we have given the time to the students for 3, so they are still joining. If we can kindly wait for 15 minutes. Am I audible? I'm not audible.
Yes, you're audible.
Okay. So sir was here with us. I think he has joined. But sir, I would request to just wait for 10-15 minutes because we have given the time slot to the students till 3 p.m. So we would start sharp at 3.
So we cannot hear you actually.
I think sir's mic is off. I'll call him up.
Ritika, please do the needful.
Yeah. It's muted, so you'll have to.
Yeah. Yeah.
Now I'm audible?
Yes, sir. Yes, you are.
That's fine. That's right. That's right.
Thank you, sir.
We would also like to welcome Mr. Soris Sundar Das, Senior Advocate, Odisha High Court. So we welcome you.
Yes, my pleasure. Am I audible? Can you hear me?
Yes, sir. Perfect.
Yes. It's my pleasure to join.
Also, as I can note, Justice Kurian Joseph is there with us. His audio and video is not yet visible. I'll try to connect to him and ask him to do the needful.
Hello. Good evening, all. We have with us Honorable Justice Kurian Joseph with us. Your Lordship, if you can hear me, I want to say that your video is not visible to us. If we can check the technical issues.
Good afternoon.
Good afternoon, Professor Rao.
Sir, my privilege.
Good afternoon, sir.
Your privilege, your honor.
Yes.
Yeah, very good afternoon to all of you.
Good afternoon,
Good
sir.
afternoon, Raj.
Good evening, all. Our world is currently experiencing a number of rapid changes that were perhaps unimaginable a few years ago or even a few months ago. We lost the early part of the year 2020 planning how to deal with this man-made disaster, COVID-19. The world at present is battling with the challenges this virus presents to us. A considerable portion of the year has already been lost, and the situation is not very clear. As a matter of fact, we all have accepted that with changing dimensions, we have to be adapted and we have to adopt the new norms. But the bigger question is, what exactly are the new norms? Are we really clear on it for all sectors? As a member of legal fraternity, at least I can say the new normal of the legal education system in India is not so crystal. Yes, in order to respond to the situations, understanding its graveness, the concerning agencies, the boards, the councils, and the concerning authorities have come up with various guidelines relating to the conduct of examination, promotion of the students, and formalities relating to the award of the degree to the students graduating in 2020. The area that's still left unaddressed is the academic loss suffered by the law students in India since the imposition of the lockdown 1. The day our union government announced the preventive lockdown measures, a wave of uncertainty and speculations gripped the legal community. Understanding the immediate need to match the requirement of the day and to contribute to the society in preventing further loss of the academics by the law students in India, we came up with this noble initiative of Legis Orbis. In less than 48 hours of our launch, We received registration from 150 plus law students from 67 plus campuses throughout the nation for the first phase of our online live law classes. In the very first month of our inception, we conducted our first webinar series on the career opportunities for the law student during the pandemic phase, wherein we invited various legal luminaries, including inter alia, Sri Salman Khurshid, Senior Advocate, Supreme Court of India, Sri Ashok Arora, Senior Advocate, Supreme Court of India, to address these sessions which received participation from 500 plus students from various parts of the India. We truly acknowledge the dynamic nature of the legal education and support the vision of the Bar Council of India with regards to the continuing legal education. At Legis Office, we are conducting various curricular activities, including inter alia, webinars, e-seminars, quizzes, blog writing, article writing, moot court, etc. Legis Office is now offering online education in more than 10 law subjects with the help of 10 plus expert members under the able guidance of our advisory board, which is chaired by Sri Salman Khurshid, Senior Advocate, Supreme Court of India. The three main core missions of our organization are education, research, and social contribution. Research and social contribution are necessary in order to pose a justified response to the global trend, which is ever changing. Education, on the other hand, has an essential nature that I truly believe to be unchangeable. With these three missions in our mind, we dedicated Legis Orbis to the entire nation, where academic endeavor have proceeded undisturbed even during the pandemic. During this phase, when everyone is dealing with the struggles of their life, we have come up with the idea which could contribute in sharing of problems from their shoulders to ours, and thereby we are making a positive contribution toward a positive nation building. And the idea of Legis Orbis is a prominent example. What was started as a mere idea has now received the cooperation and recognition from the bench, the bar, the academic institutions, the corporate houses, the law firms, and the society at large. What we are witnessing today is a display of what can be done with sheer amount of dedication, commitments, and hard work. Today, I feel proud to present to you all India's first and biggest e-seminar titled Life, Liberty and Privacy, the Indian Jurisprudence on Individuals' Data Privacy in association with LexisNexis. To honor today, we have with us Honorable Justice Kurian Joseph, former Judge Supreme Court of India, and Professor Dr. Venkata, former Vice Chancellor, National Law School of India, University, Bangalore, to address the inaugural session of this seminar. I, on behalf of the entire Legis Office family, welcome His Lordship, Honorable Vice Chancellor, paper contributors, participants, and the students of law who has connected with us electronically here and on our live YouTube feeds. I would now request our co-founder, Ms. Ritika Ritu, to deliver the opening remarks. Thank you.
Good evening all. Ours is an age of information, more particularly electronic information. No doubt, even today, information is knowledge, but technology is more powerful, as it has practically and fundamentally interconnected life of individuals. Internet has taken over everything, and metaphorically, it can be termed omnipresent. Even today, when Legis Orbis is hosting its first and India's claimed biggest e-seminar in association with LexisNexis, it's getting possible because of the technology and the internet. Internet not only aids the free flow of information, but also connects people, provides a platform for e-commerce, e-teaching, e-banking, e-trading, e-reading, e-booking, etc. Unsurprisingly, it comes with uninvited problems as well, as every transaction performed with the help of internet leaves electronic tracks, generally without the knowledge of the user. These electronic tracks contain data and information which provides insight on the kind of person the user is and her interest. Precisely, this information gives a picture of the being and the things that matter, and therefore raises the privacy concerns that depict serious issues in the age of information and technology. More particularly in a democracy where the right to privacy has taken the shape of fundamental rights by virtue of judicial activism. The uniqueness of the constitutional jurisprudence could be evidenced through the extended dimension of Article 21 of the Indian Constitution, Right to privacy is one of those rights which have come into existence after widening of the purview of Article 21 of the Indian Constitution. Initially, the Constitution of India didn't guarantee the right to privacy, but the Honorable Supreme Court of India, in order to articulate and enforce what is beneficial for the society in general and people at large, through its landmark judgment delivered on August 24, 2017 in the case of Justice K.S. Puttaswamy retired versus Union of India, enforced the right to privacy of 1.3 billion people as one of the essential fundamental rights. The Honorable Apex Court, while delivering the Puttaswamy judgment, not only overruled its two early decisions, that is MP Sharma versus Satish Chandra in 1954 and Kharak Singh versus State of UP in 1962, which had held that privacy was not a fundamental right, but also declared that the right to privacy is protected as an intrinsic part of the right to life and personal liberty under Article 21 of the Constitution and as a part of the freedoms guaranteed by Part 3 of the Indian Constitution. The judgment of K.S. Puttaswamy has an incidental implication on the complex relation between the personal privacy and the big data, particularly in the context of how the judicious use of these technologies can result in the state achieving its legitimate interest with greater efficiencies. This case has recognized the impact that non-government entities can have on personal privacy, particularly with respect to informational privacy on the internet. While it is very clear that fundamental rights could be enforced only against the state, looking the broad language of this, the various experts have stated that it could be extended to private sectors as well. This judgment has definitely widened the regime of right to privacy and is definitely going to bring a large number of sectors infringing the privacy laws within its purview. It is hoped that conducting a discussion among legal luminaries, academicians, members of the bench, members of the bar, and enforcement agencies during the proceedings of this e-seminar would be fruitful at a time when the dimension of right to privacy is changing vividly in India. The suggestion of various stakeholders in preparing database for the lawmakers and policy planners to appropriately frame a data protection law to address the concerns relating to data protection, data privacy, and the privacy of individuals in what is being called as Digital India. The themes chosen for this e-seminar are as follows: privacy and the data protection framework, the Indian contact tracing app Aarogya Setu, biometric identification in India, the Aadhar chapter and the fundamental right to privacy, protection versus privacy, the expanded surveillance scheme, doctrinal shadow of the Indian Constitution over the right to privacy in digital India. So I would now request our co-founder, Ms. Rajeshri Kanungo, to introduce and welcome our honorable guests for the evening. Thank you.
Good evening, all. I feel privileged and honored to welcome on behalf of the entire Legis Orbis family our revered guest for the evening, Honorable Mr. Justice Kurian Joseph, former Judge, Supreme Court of India, and Professor Dr. R. Venkata Rao, former Vice Chancellor, National Law School of India, University, Bangalore. Honorable Justice Kurian Joseph was born on 30th November 1953. He received education from St. Joseph's UP School, Chengal, Kaladi, St. Sebastian's High School, Kanjur, Bharatamatha College, Srikakara, Sri Sankara College, Kaladi, and the Kerala Law Academy Law College, Thiruvananthapuram. His Lordship was member of the Academic Council, Kerala University, from 1977 to 1978, General Secretary of Kerala University Union in 1978, Senate member of Cochin University from 1983 to 1985. His Lordship began legal practice in 1979 in the Honorable High Court of Kerala. He served as a government pleader in 1987 and as an additional Advocate General from 1994 to 1996. His Lordship was designated as Senior Advocate in 1996 and was elevated as a Judge of Honorable High Court of Kerala on 12th July 2000. He was the President of Kerala Judicial Academy from 2006 to 2008, Chairman of Lakshadweep Legal Services Authority in 2008, Chairman of Kerala High Court Legal Services Committee from 2006 to 2009. He also served as an executive chairman of Kerala State Legal Services Authority from 2009 to 2010. His lordship served twice as the acting Chief Justice of the High Court of Kerala and was appointed as the Chief Justice of High Court of Himachal Pradesh, wherein he served the office from 8 February 2010 to 7th March 2013. Honorable Master Justice Kurian Joseph was elevated as the Judge of the Supreme Court of India on 8th March 2013. He got retired on 30th November 2018 after serving his honorable office for more than 5 years. Professor Dr. R. Venkata Rao was born on 15th March 1954. Sir is the former Vice Chancellor of the National Law School of India, University, Bangalore. His academic qualifications are BA Honours Literature, MA Literature, ML, and PhD and LLD Honoris Causa 2017, Utkal University. Professor Dr. Rao has served for 31 years in the Faculty of Law at Andhra University in various capacities as the Dean, Faculty of Law, Principal, University College of Law, Chairman, Board of Studies in Law, and Head of the Department of Law. Professor Dr. Rao's primary area of research is human rights, humanitarian law, and criminal justice. Sir has received the prestigious Professor N.R. Madhav Menon Best Law Teacher Award for 2018 and has the distinction of receiving the Best Teacher Award. Sorry, sir. Best Teacher Award from the Government of Andhra Pradesh in 2006, the Best Research Award from the Andhra University in 2003, and a gold medal for the Best PhD Thesis. He has also been awarded the Best Vice Chancellor Award for outstanding contribution to education during the World Chancellors and Vice Chancellors Congress 2014 held on June 27, 2014 at Mumbai. Amity University Noida awarded Amity Academic Excellence Award for the most distinguished contribution towards the propagation of doctrine of knowledge. Professor Dr. Rao served as the chairman of the Board of Governors, Asian Law Institute in 2010 to 2011 and has been an independent director in the prestigious public sector undertakings like Bharat Electronics Limited, Bangalore, Hindustan Aeronautics Limited, Bangalore, Goa Shipyard Limited, Goa. He is also the member of the Board of Governors of IICA, New Delhi. He is also a member of the Legal Education Committee, Curriculum Development Committee, and the Equivalence Committee of the Bar Council of India. I welcome Honorable Mr. Justice Kurian Joseph and Professor Dr. R. Venkata Rao to the India's biggest e-seminar on the right to privacy brought to you by Legis Orbis in association with LexisNexis. And I now request Professor Dr. R. Venkata Rao to kindly address the August e-gathering.
Thank you very much. Good afternoon. Am I audible to you?
Yes.
Yeah. That's most respected, revered, Honorable Justice Kurian Joseph, Abhishek, Ritika, and other members of the family of Legis Orbis, distinguished participants. It's a privilege and honor for me to participate in today's e-seminar on life, liberty, and privacy, the Indian jurisprudence on individuals' data protection. It's a privilege because you have thrown me onto the virtual platform into the distinguished company of an eminent person, Honorable Justice Kurian Joseph, who was my mentor and who guided me as a member of our governing council in National Law School of India University during my sojourn in National Law School of India University, Bangalore, and which to a great extent was responsible for me doing my best to National Law School of India University. I'm grateful to your Lordship, and it is a rare privilege for me to be in his august company, and my grateful thanks to Legis Orbis. Today, the Indian jurisprudence revolves around the Constitution of India and the Supreme Court of India. I would like to speak about the Constitution of India and Supreme Court of India for 5 minutes before going to the topic proper. The Constitution of India is 70 years young. I call it young because institutions would always be young. They would never become old. And it's only human beings who become old. And Indian Constitution is an institution which has won the confidence of rank and file to such an extent that they consider it as a holier scripture than the holiest scriptures in the country. Look at the preambular aspirations where you have two important words: securing to citizens justice, liberty, equality, and promoting among them fraternity and dignity. And dignity is the focus. And this constitution has grown from strength to strength in the last 70 years. And the scope of a fundamental rights chapter has been expanded by the Supreme Court of India in such a wonderful manner that this great institution is looked at with awe and admiration by all right-thinking persons all over the world. Professor Upendra Bakshi, in his typical pithy manner, once observed, India might have had become republic in 1950, but the Supreme Court became republic only in 1970s. He said that because for the first 25 years, more or less, the Supreme Court revolved around proprietariat jurisprudence. But from 1978 onwards, thanks to the advent of judges like Justice Krishna Iyer, Bhagavati, Chinnappa Reddy, to name some of them, the Indian Supreme Court has started evolving new principles of administrative law. Professor Bakshi says, up to 1978, for principles of administrative law, the Supreme Court of India used to look to the decisions of the Supreme Court of United States, decisions of the then House of Lords, United Kingdom, French administrative courts. But from 1978 onwards, the Supreme Court's contribution has been so epoch-making that today, with respect, awe, and admiration, the Supreme Court of United States, the Supreme Court of United Kingdom, administrative courts in France, over Europe and Australia, they quote the decisions of the Supreme Court of India, and that Supreme Court of India has made phenomenal contribution in opening a new leaf of jurisprudence where the focus is individual and individual. With this backdrop, I would also share with the participants three important contemporaneous trends all over the globe, which are responsible for individual becoming the sinusole of everyone in jurisprudential analysis. Those three are the growth of the liberal individualist tradition, which has stressed in particular three personal ideals, to each of which corresponds a range of private affairs. Those three ideals are the ideal of personal relations, the second one, the Lockean ideal of the politically free man in a minimally regulated society, and the most important one, the third one, the Kantian ideal of morally autonomous man, acting on principles that he accepts as rational. So Kantian ideal of morally autonomous man, minimally regulated society, and the ideal of personal relation. This wave has been sweeping all over the world, and the Supreme Court of India was also impressed by that. Now coming to Justice Puttaswamy's case, as rightly pointed out by Ritika, this was a sequel to the opinion of bench of three judges of the Supreme Court, which, while considering the constitutional challenge to Aadhar card scheme of the union government, noted that the action of the government was questioned on the ground that it violates the right to privacy. And when it was questioned, the Attorney General was on record stating that the right to privacy was in doubt in view of the opinion expressed by the Supreme Court in MP Sharma versus Satish Chandra, which was rendered by a bench of 8 judges, then in Kark Singh versus State of UP, which was rendered by a bench of 6 judges. And on the other hand, it was also submitted that the exclusionary theory of interpreting fundamental rights that was propounded in Gopalan's case was nullified in 11-member bench decision in R.C. Kopar's case. And after 7-member bench judge in Maneka Gandhi versus Union of India, Gopalan's case had no applicability. The Supreme Court also observed the dissenting opinion of Justice Subbarao in Karak Singh's case, the court noted that there are some decisions of the smaller benches of Supreme Court which have already brought right to privacy under the gamut of fundamental rights. Those cases were Govind versus State of Madhya Pradesh, Rajagopal versus State of Tamil Nadu, and People's Union for Civil Liberties versus Union of India, among others. Puttaswamy's case, in fact, attempted to give a quietus to the matter by holding the right to privacy is implicit in the right to personal liberty under Article 21 of the Constitution of India and overruled the decisions to the contrary. From a perusal of the judgments in Puttaswamy's case, one can infer from that permissible limits for invasion of privacy are three. Number one, there must be the existence of law. Number two, there must be legitimate state interest. And number three, that law should pass test of proportionality. I repeat again, there must be law in existence, there must be legitimate state interest, and that should pass the test of proportionality. And this fundamental right to privacy has both positive and negative connotations. Its positive content imposes an obligation on the state to take all necessary measures to protect the privacy of the individual. The negative content restrains the state from committing an intrusion upon life and personal liberty of a citizen. In this backdrop, when we are living in the age of fourth industrial revolution, which is a systems revolution and not a product revolution, certain issues have to be raised. Rousseau long ago said, man is born free and everywhere he is in chains. With apologies to him, can we say, man is born free, but everywhere he is in digital chains now these days. The second issue is, are technology companies serving as instruments of freedom or instruments of control? The third issue is, has the surveillance of the private citizen become the norm rather than the exception? Number four, is the state treating its citizen condescendingly with little consideration for Puttaswamy's decision, in spite of the fact that privacy is now a fundamental right and cannot be trampled upon without adequate checks and balances? Then growing threats to our privacy and relentless development of surveillance technologies and the willingness of the government to exercise these technologies against its own citizens are now realities that citizens in many countries are facing. Two issues I would raise, because I have also come here to listen to the erudition of His Lordship. Protecting private data, and number two, facial recognition as the ramifications of right to privacy. Coming to protecting private data, after the cabinet has cleared the personal data protection bill, now it is before the Joint Select Committee, of course. The positive aspect of it is the first legislation that lays down concrete principles for the protection of personal data. It is also the first codification of the fundamental right to privacy affirmed by the Supreme Court in 2017 judgment. And this data protection bill lays down the principles by which data would be judged personal, data would be judged sensitive, and data would be judged critical. And the bill mandates processes by which such data may be obtained with consent and can be stored and can be processed. But this bill is not a comprehensive privacy law because there are many gray areas left unaddressed. And they may need extensive amendments or follow-up legislation before it offers adequate protection to citizens. The initial draft was prepared and presented in July 2016 by a committee headed by His Lordship Justice B.N. C. Krishna. The delay was caused by multiple amendments and interministerial consultations, but the irony is the consultation process has been unusually opaque. The ministry has refused to make any of the comments received publicly, despite multiple right to information requests and questions in Parliament. This generated a controversy with Justice Sri Krishna himself stating that comments should be released now that the consultation process is over. However, the bill offers the state wide latitude to conduct surveillance and to collect data without consent for many purposes. It permits processing personal data for prevention, detection, investigation, and prosecution or any other contravention of law. This latitude, in my opinion, effectively drives a truck to the right to privacy, given the lack of legal safeguards. And the draft is also supposed to access all non-personal data. And the definition of non-personal data is so broad. Therefore, what is required is a thorough analysis of this bill by the public, and adequate safeguards should be inbuilt, because this draft also reportedly asks social media networks to set up systems for verifying users. This could lead to a sharp erosion of freedom of expression in India's social media space if it is used to target critics of government policy. As Edmund Burke has long ago said, governments and individuals have always been at loggerheads as far as liberty and security are concerned. And Benjamin Franklin's statement, I may recall, those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety. The tension between the government power and individual liberty has been eternal. Therefore, adequate safeguards must be built in this protection the bill. Despite all these gaps and flaws, I personally believe that this is the first attempt to have a basic framework for personal data protection, and therefore it's important, but the safeguards are required. The second issue which I wanted to refer is the facial recognition technology, which without an adequate data protection law makes technology unregulated, and it can corrode and destroy freedoms. There was a brilliant research paper written by Mishi Chowdhury and Evan Moglen, professors from Columbia Law School, on this particular aspect, wherein they say, I quote, in the 21st century, an Aadhar number, a mobile handset, and the unique network address of a Wi-Fi adapter in smartphones can locate users in a digital world. From financial transactions to interpersonal communications, from web searches to everything that a person reads, watches, or listens can be used to identify almost everything we touch, we do, and we think. Once cameras are connected to a facial recognition software, citizens have no privacy anywhere. And therefore, technology can be used to quote authors to perfect despotism. That's what they said. And this, in Chinese context, they use the word digital authoritarianism. Well, friends, facial recognition is only just one form of identification. Even if it is controlled or forbidden to use on the public, all the other forms of digital identification, when accompanied by comprehensive behavioral collection and secretive data analysis, are a threat to autonomy of each individual. Therefore, there is a need to regulate the industry on behavioral collection and subject the government surveillance to the rule of law and not the rule by law. Nowadays, the focus seems to be more on rule by law than rule of law. Therefore, what can be done? The authors wonderfully suggest, as in Europe, we should declare a 5-year moratorium on all public space facial recognition, both governmental and private, to allow time for society and law to catch up. Parliament should make, by statute, a strong personal privacy charter by protecting the rights of everyone to be free from forms of behavior collection and mass data analysis that are demonstrably harmful. Such an act should not have any exceptions. It should subject all government surveillance and government use of private surveillance technologies to the rule of law. Then only this facial recognition tech will not be impacting the privacy of the individual. Finally, I'd like to just raise 4 important issues in post-Potoswami developments in view of the exponential development of technology. Number 1 is, can individual privacy be the trade-off for availing efficient services? Number 2, can right to privacy be waived? Is it not a pre-constitutional right? Then if you say right to privacy cannot be waived, will it not affect your right to privacy? When I say you cannot waive your right to privacy, am I not impacting your right to privacy? These issues continue to elude definite answers. With this, I would like to thank the organizers for having given me this opportunity of sharing my thoughts on the Indian jurisprudential quotient of data protection of the individual, and I look forward to the erudition of Honorable Justice Kurian Joseph, sir. Thank you very much, ladies and gentlemen. Thank you.
Thank you, sir, for enlightening us. I would now invite the chief guest of the evening, His Lordship Honorable Mr. Kurian Joseph, to kindly address the August e-gathering.
Thank you. As you rightly said, I'm a guest here. We have a speaker and I'm a guest. So it's a great honor to me to share a stage with Professor Venkata, a great scholar and a guru. And you know the meaning of a guru. Guru means the one who removes darkness in the minds of the disciples. So how many he has been raised in the superior courts across the country. Well, that was something very interesting to listen to. Once a teacher has spoken, there is no role for a student to speak. It has been so enlightening, and you know, we have so many questions passing through our minds also. So, in fact, I put a note to Ritika on listening to Professor Venkata, that probably instead of my talk, we could have a little discussion, because we should have so many questions we can ask to Professor Venkata, who has done an in-depth study into all these things. But just to help you to have such questions coming, either you can have it in the chat box, or you can talk directly or system. But I was just wondering, you know, apropos to what Professor Venkata said, you know, see, we have a constitution which has secured our fundamental rights. It's our constitution. We made it for ourselves. So we restated our rights and articulated some of them as fundamental rights. As Professor Venkata said, it's not as if the constitution gave rise to rights. You know, constitution only articulated the rights which are available to the citizens. Rights are already there. To me, I would say right to privacy is a human right. It's not only my interpretation, it is generally seen so. So if it's a human right, to what extent that will go to the root of the question of a dignity of an individual. Once I said securing the fundamental rights, the second catchword I would like to take from the Constitution is assuring the dignity. These are the two words. Securing fundamental rights and assuring dignity of the individual. I do not think that there is any constitution in the world where it has secured to all citizens the fundamental rights and it has assured dignity of the individual. See, once you say dignity of the individual, there's some difference. Fundamental rights is secured to the citizens. Dignity to the individual. Who is this individual? When you go to Article 21, it's not something available only to the citizens. No, it is available to any person. You go to Article 14. These are two rights, which are available to individuals. Any person who is a non-citizen in this country also is entitled to that this right. So we have a constitution which has held in such a high pedestal, the dignity of the individual. It is this assurance of the Constitution of India which has been seen through in Puttaswamy's case, and where the court has been, had that constitutional vision and that human right perspective in holding that this is a fundamental right. Once it is a fundamental right, it can be regulated only on four main particular aspects. One, public order. Two, health. Three, morality. And other parts of the Constitution. These are some of the reasonable restrictions. Public order, health, and morality may be, you can say, a reasonable restriction. There cannot be an absolute negation of a fundamental right. That was what was tested under the 42nd and pre-42nd also, the emergency also. It's now the rule of the land that there's an absolute that is because it is so fundamental to the existence of a person in this country, and it is so fundamental for a citizen to live in a democratic country that is India, because India is a sovereign, socialist, secular, democratic republic. Once you say democratic, that simply means, in simple terms, that every citizen has a space in this country and he has a voice in this country. So it is a space in this country. How secure, how autonomous is in that space is the big question. That's where we have to analyze the dignity aspect of the person. And mind you, Article 21, it is the duty of the state to protect this dignity, because protection of life and personal liberty is the fundamental right of a person. Then it becomes a fundamental obligation of the state. If I have a right, you have a duty. That's our fundamental basis of jurisprudence also. No? So it is my right, so it is your duty, state's duty. So how far the state in the Personal Data Protection Bill proposes to safeguard, preserve and promote this dignity of individual in this country is the big question that we have to analyze and discuss. As Professor Rao rightly said, this is something which we need to discuss. If we want to live as a free citizen with the dignity, live with the dignity is, of course, a fundamental facet of this fundamental right to life. So, if you want to live a dignified life, that means your certain aspects of this life are to be protected. In that, your privacy is one of the very serious aspects. To what extent the state can be permitted to intrude into your privacy so as to subserve the larger interest of the state or the welfare of the state. So in the larger interest of the welfare of the people, to what extent the state can intrude into the privacy of a person, number one. Number two, where is this data stored? That's a very, very serious question. You collect your data, but where is it stored? This data, as you know, is stored actually in some foreign countries. Suppose this data is actually used, processed by those countries. Is it not even a threat to the security of this country, leave alone the personal dignity of the person? All Indians' whole data is stored in foreign countries. So how are they going to if they what's the protection available to India? That they won't make use of this data, they won't misuse, or they don't make an impermissible. I don't say misuse. They don't make an impermissible use. Who is going to check? What is the restriction of that? So how far are we? How far the state should go ahead with the collection of data of a person to the extent of violating his right to lead a dignified life. And dignity, as Professor Rao rightly said, I was just waiting for this word. Anything that affects your autonomy affects your dignity accordingly. We have had a very serious discussion these years on account of our Sabarimala case, which is still now pending in a review as to what is this constitutional morality. One of the important aspects of constitutional morality or factors is dignity of the person. So, how far we are able to protect the dignity of the person. And I'm happy again, I would like to again endorse whatever Professor Rao said, though all of us are born free, now we are in a digital chain. So to what extent the digital chain has cribbed, cabined and confined me, so affecting my liberty of thought, expression, faith, belief and worship. On these 5 aspects, our liberty is not a very vague thing. It's a very, very specific, because it touches all aspects of a person's existence as an individual and coexistence in society. So my existence as an individual in a democratic country and my expression of myself in a democratic country with a coexistence with my fellow citizens are all actually reflected in these 5 liberties: thought, expression, faith, belief and worship. So in that sphere, now my dear friends, we may have to take, if we want to live a life as a proud Indian, where our individual rights are not only respected but protected. Respect is by us, and respect should also be by state. But only the state can protect it. So how far these individual rights on privacy are going to be respected and protected by the state is a very serious question. Probably we may have to analyze in these coming days before the bill actually goes for a wider discussion in the parliament. I am also not quite happy the way that the discussions have not been. Justice Sri Krishna was with us. In fact, I participated in one of the webinars conducted by Justice Sri Krishna on this personal data protection issue, where his lordship also expressed this unhappiness about the state not actually letting out the discussions on that. So, to what extent this regulation can go? What do you mean by this reasonable restriction? The regulating the individual's data of so with this broad note, I'm not going to any specifics because I'd like you to interact, because both of us do not know what you want to know. Professor Rao has given an excellent exhortation on this issue. I have only just added a broad points into this spectrum because I want you to interact with Professor Rao, and to some extent I can also, because then only we will know what you want to know on this topic. Thank you.
Thank you, Lordship. Now we have a few questions from the audience. The first question is directed for Your Lordship. Your Lordship, Priti Tripathi wants to ask, why is there being so much difficulty in bringing the entire realm of cyber security in India under one roof? The problem being so many rules for interpretation create a legal conundrum in handling cyber issues.
I couldn't get you fully. Can you just repeat it?
Yes, Your Lordship. Your Lordship, the question is, why is there being so much difficulty in bringing the entire realm of cyber security in India under one roof when different rooms for interpretation are possible, which creates legal situations and issues in handling cyber issues?
Yeah, see, as far as Information Technology Act is concerned, you must know information technology is one of the legislations where we have, the scope is so wider. One of the very few legislations where we very few particular strict interpretation of any applicable law. Reason is, the cyber law is changing day by day because newer and newer challenges are coming. Therefore, the cyber security is a big issue as far as the country is concerned. I am yet to know why the state, rather the country, India, such a country with so much of an advanced technology, should be taking this high risk of our cyber security being entrusted in foreign hands. Professor Rao, would you like to add something to that? I'm sure you have something to add.
Yeah, yes, sir. Yes. My lord, I would like to only focus on what the Supreme Court essentially said in Shreya Singhal's case. And in Shreya Singhal's case, the court defined the key rules for the relationship between democratic government and commercial internet platforms. And the case called on courts and government agencies and not companies like Google or Facebook. That's very important aspect of shares in this case. To decide what speech and information violates law and must be removed from public view on the internet. So the responsibility is given to the court and the government, number one. In that way, I consider Shreya Singhal's case to be a landmark decision. It should be followed by all courts in the world because it has not given free hand to free players. But I would like to share with the young man a very important facet of the fourth industrial revolution, which is responsible for the so-called artificial intelligence, robots, drones, intelligence, cities, then brain research, etc., etc. Now, the fourth industrial revolution, which is a systems revolution and not a product revolution, unlike earlier revolutions, very important point of view is Klaus Schwab, the president of World Economic Forum, has said, I quote him, if we do not want to be dominated by technology, we have to become a more human society. That's what he said. What leadership style, what capabilities do we need to master all these technologies? He said, a robot cannot replicate the human heart. A robot cannot replicate the human soul. It may replicate the human brain. And he also wonderfully said, what is artificial intelligence? After artificial intelligence is an attempt to mechanize human thoughts. But all human thoughts can never be mechanized. And therefore, in the fourth industrial revolution, what you should have is a new human renaissance. And if we do not want to be dominated by technology, and that new human renaissance should focus on dignity and dignity alone. And in fact, the Supreme Court has delivered goods in Shreya Singhal's case by focusing on the dignity aspect. And that's the reason why the cyber space is being brought incrementally within the umbrella of legal regime. One thing we must understand, technology changes at an exponential pace, whereas lawmaking is very slow. And here you have to understand the basic difference between a democracy and authoritarian setup. In a democracy, lawmaking is very slow but certain. In an authoritarian setup, lawmaking is very fast but totally uncertain. And therefore, we may take time to make law to bring cyberspace within legal regime in an incremental fashion. And in the meantime, we should not lose patience. Sir, in fact, I may share with you, Thomas Friedman has written a marvelous book, the title of which is Thank You for Being Late. So we may be late, but you should not get panicky. Definitely a time will come when the entire realm of cyberspace will be brought within the legal regime But dignity should not be a casualty. If we do it in a hurry, the individual will be dehumanized. Remember, all activities are meant for human beings. Thank you, sir. That's it.
To tell you one more thing in connection with this also, no? Well, I was a judge, sitting judge. There was a case in public interest requesting the Supreme Court to ban all the pornographic sites. So we sought pornography affects the dignity of individual. I do not want to illustrate it any further. It affects the dignity of an individual because it affects your right to life in Article 21 also. So we passed an order, after ascertaining the governments. 66 sites were banned by the government of India.
Yes.
But next day, 1,000 sites more came in different names. This is how volatile this cyber space is as of now. So, making law on a regulation of cyberspace and cyber security is a humongous task for any country, because it is that is the shape of its cyberspace.
So there is a follow-up question. So the idea of voter manipulation through social media qualify as cyber fraud or a criminal offense under the Representation of People's Act? I repeat again. Should
Yeah,
the
I
idea...
thought it has been held as a manipulation under the Representation of People's Act. Supreme Court has held it so. The manipulation of the vote through social media is actually a corrupt practice under the Representation of People's Act.
So there is another question. What's your take on the government decision to make mandatory uses of Aarogya Setu app while undertaking air travel in India?
So what is Aarogya Setu? So unless you know what is Aarogya Setu, because it monitors all your personal data about your health, about the place where you come from, the place where you go, the places you have traveled. All these are monitored. How do they monitor it? Something very interesting. It's all monitored not by a chip that is planted in you, but by a chip that you carry with you. That is the difference. There are actually some moves. I think, Professor Rao, am I right? In some countries, I think there's a chip planted in the body of every person, I'm told. So that everything can be monitored. Wherever he goes, whatever he does, whatever he engaged in, everything can be monitored. But that's not the situation as of now in India. But we have a dangerous weapon with us. We carry this mobile phone. So with this mobile phone with us, it can be monitored that all. So there is a positive note as far as Aadhar Setu is concerned, because your health is monitored, because your health is not only your preoccupation in particularly in the health. Professor Rao, would you like to add anything?
No, sir, absolutely. Right, sir.
This question is directed to Professor Rao. When the government is making Aadhar data available to private entities for smoothing banking and telecommunication system in India, what are the privacy concerns, and do we have framework to address this issue?
It is to Professor Rao, they said. It is addressed to you.
Hello.
Professor Rao, this question was addressed to you, they said.
Yes, sir. I have not followed the question. Kindly repeat the question. Please test it so that it's visible on the screen.
So it's there. I'm just repeating it.
Yeah, please repeat.
It's there on the screen. When the government is making Aadhar data available to private entities for smoothing banking and telecommunication system in India, What are the privacy concerns, and do we have proper framework to address this issue?
Absolutely, that's what I said. See, when you are looking at the data protection bill, okay, remember, we need to examine this particular issue. Unless you have adequate safeguards, remember, sharing the information with the private agencies, remember, is dangerous. It's likely to, remember, backfire. And the process dignity will become the casualty. And therefore, I told you, we need to have a basic framework for personal data protection. In the absence of that legislation, it is easy for government, armed, and the private sector to indulge in overreach and collect data without consent, as indeed has occurred in 2 years since Supreme Court ruling in Puttaswamy's case. See, Puttaswamy's ruling was given 2 years ago, okay? And if you have seen that the development that have taken place, most of the things are taking place as though Puttaswamy's decision is not there. That's the reason why I'm saying you need to have a basic framework, and all these appropriate concerns which have been raised, the gaps in the legislation have to be plugged. Otherwise, remember, privacy will become the casualty. Right.
Thank you, sir. Your Lordship, there is one question directed to you. What is your opinion on the use of unauthorized apps and softwares being used by the universities and colleges which are not secured and are harmful for the students?
The moment you say unauthorized, anything unauthorized, anything unauthorized is against the principle of rule of law, because it becomes rule by law.
Yes.
So don't go for unauthorized. Always go as a law-abiding citizen. Unauthorized means it's not authorized to be used under law. So therefore, be it a university, be it a judge, be it a court. That's why we are the famous saying, howsoever high you may be, you are not above law. So therefore, don't go for unauthorized. Unauthorized apps are certainly dangerous. It can invite, it may be, this is like the games that you play. It may give you a certain amount of immediacy, what you call expediency at the first blush, but it can lead to more dangers, which you cannot retract on. Once you are into, then you are trapped. You cannot retract. So don't go for unauthorized.
There is another question. Privacy is often misunderstood with secrecy. What do we have to hide to want such a fundamental right? I'm pasting this question for your Lordship perusal.
Yeah, as the young man who asked this question, privacy and secrecy, those are two things. Privacy and secrecy. Secrecy operates in a different field jurisprudentially. Privacy operates in a different field jurisprudentially. Your right to privacy does not mean your right to secrecy. But suppose you commit an offense in secret. That's something secret. Can you say, no, that is my private affair, you have no business? Suppose you indulge into a sexual offense with a person in secret. And suppose this becomes, as Professor Rao said, one of the 4 elements: investigation, prevention, investigation. 2 elements come into play: prevention and investigation. Can you say or distinction to privacy according to you? Would you like to add the Professor Rao as far as jurisprudential aspect of privacy is concerned?
Absolutely, sir. This is it.
Yes, sir, we can hear you.
Yeah. Yes.
Yeah. So therefore, you are entitled to a protection to your privacy, not your secrecy. Yeah, this is what I wanted to say.
Right.
So we are taking the final question. Our data have been found in the servers of South Asian countries. There is a pertinent threat to our military also. Keeping in view the means of modern warfare are also changing. doesn't this create an urgency to have national data regulation policy, particularly when the Honorable Supreme Court of India has recognized the urgent need to have our own data protection law?
100%. You look at the South Asian countries, qua India. That's the whole problem. You are in a potential danger of being always under the surveillance of all these neighboring countries in South Asia. Therefore, from the security point of view, definitely it's a grave concern, particularly when you have this clone, drone, all this coming in, and therefore your data protection should be your immediate concern as far as from the security point of view the country is concerned.
The final question directed to Professor Rao. Is this advancement of technology infringing right to privacy, not calling for global administrative law since we cannot limit the violation to a national boundary? So I'm just copy pasting this question.
Yeah, please copy paste it.
It's on the screen, sir. Is this advancement of technology infringing right to privacy, not calling for global administrative law since we cannot limit the violation to a national boundary?
Yeah, now I'm reminded of Steve Jobs' observation, how happy and peaceful was life when Apple and BlackBerry were just flukes. Okay, now technology advances, okay, but it doesn't mean that technology can be allowed to become a Frankenstein, isn't it? We have the wherewithal, okay, and as somebody said, the Stone Age for 1 million years. Okay, the Industrial Revolution was for 60 years. The Information Revolution was for 20 years. And you do not know how long is going to be Internet Revolution. But in all these, God has been wonderful to endow us with what is called Darwinism, to adopt ourselves to the changing requirements. But only one thing I would like to request all of you to understand is, all of us, including me, we believe in instant gratification. We refuse to understand the difference between immediate and distant. What I mean by instant gratification is, myself, let us say, if Google asks me to furnish information in a hurry to comply with the contract, I'll furnish all the information. And later I would say Google had violated my privacy. But immediately I would like to have instant gratification. Therefore, remember that self-regulation is very important here. And we have to take advantage of technology without we becoming servants of technology. And therefore, technology should become a boon and not a bane. And if it becomes a boon, we can regulate our conduct. Thank you. Okay? Right.
So don't allow privacy to be traded.
Yeah, exactly.
I thought some of your youngsters should ask this question. Don't allow our privacy to be traded.
Yes, that's the reason why, sir, I have raised the question, can it be a trade-off for availing efficient services? So for instant gratification, for efficiency, you trade off your privacy. Okay. It is like entering into contract with Mephistopheles of Dr. Faustus. Remember, it will be a Mephistophelian contract. Okay, right, sir. Right.
And second endorsement, if it is a pre-existing constitutional right and which is also a human right, don't waive it.
Exactly, sir, you're right.
Yeah, these are two notes I want you to take home. After you may forget everything else, but please take home these two things. Don't allow it to be traded. Don't allow it to be waived.
Wonderful, sir.
Whatever gratification, proximate or remote.
That's right, yes, sir.
Thank you so much, Professor Rao. It was a pleasure listening.
My pleasure, sir. I'm honored.
Always get gurus like you. Whole problem in this country today is, we lack gurus now.
Thanks.
We have teachers, but not gurus. Yeah, thank you, ladies, for this thoughtful session. And since you are students of great interest on these areas, probably as stage 2, you can approach Justice Sri Krishna, we will only be happy to share a stage with you on this discussion on data protection. Very illuminating. Teachers will get.
Sure, sir. Sure, sir.
Thank you. Congratulations to all of you. God bless you. Stay safe.
Thank you very much, sir. On behalf of this family, take this privilege to have been asked to propose a vote of thanks on this occasion. I would like to extend my hearty vote of thanks to His Lordship, Honorable Mr. Justice Kurian Joseph and Professor Dr. R. Venkata for accepting our invitation to this e-seminar and addressing the e-gathering today. We are definitely enlightened with the word of wisdom from our revered guest. I would also like to take this opportunity to thank Professor Dr. Jayadev Pati, former principal, MS Law College, and current legal advisor of SOA National Institute of Law, SOA University, Mr. Soresundar Das, senior advocate, High Court of Orissa, and senior member of advisory board to Legas Orbis, Dr. Madhurata Mohanty, and Mr. Prabhu Prasanna Behra to have attended this session. I would also like to take this opportunity to thank LexisNexis for associating with our event as title sponsor. I also extend my heartfelt thanks to the members of bench, bar, academic institutions, all the law universities in India, students, and the members of press and media who have contributed to make this event a grand success one. I also like to thank the participants of this first kind of e-seminar who will be sharing their online presentation from tomorrow onwards till we complete this event with our valedictory ceremony, which is scheduled on 25th July 2020. I also like to thank each and everyone who is associated with Legis Orbis and who have put their sweat and blood to make this event possible and grand success. Thank you all. Thank you, sir. Thank you, Your Lordship.
Thank you so much for ending this webinar on time. This is the first webinar I attend which has ended dot on time. Started 1 minute early, but ended dot on time.
Thank you, Doctor.